Okay, well, everyone is so quiet that I think we should get started. That was really good. I'm Randy May, president of the Free State Foundation, and I'm pleased to welcome you to the Free State Foundation's 9th Annual Telecom Policy Conference. I want to extend an especially warm welcome to our C-SPAN audience. I'm a self-confessed C-SPAN junkie. Some of you may have heard me say that before. My mom, may she rest in peace, she always worried when I told her I was a C-SPAN junkie, not really knowing what I meant by that. But I'm always pleased and grateful when C-SPAN is here, and welcome to the C-SPAN audience. This year's annual conference follows on the heels of the 10th anniversary gala last December. So with next year's annual conference, we'll be in double digits for this event too, which just confirms the old adage that time flies when you're having fun, and I might add when you're busy as well. Almost every year I say, some of you know this, I say that our annual Telecom Policy Conference just keeps getting bigger, better, and more impactful. Well, as long as it remains true, I'm going to keep saying it. Even though we had to reschedule this year's conference because our first date, March 14th, happened to be the only snowy day this winter in Washington, I think this year's conference upholds the tradition. A quick glance at the program shows why the conference is a must-attend event for anyone interested in communications, internet, and high-tech law and policy. I know you will agree we have an outstanding group of speakers and program sessions. The program that you have here, it's also on our website. If you need another copy or want to download it, near the top of our home page. The theme for this year's conference is a new direction for communications policy, less regulation, more investment, and innovation. With a new FCC and a new Congress in place, the opportunity is ripe for charting a free market-oriented direction for communications law and policy. As most of you know, at the FCC, under the leadership of new Chairman Ajit Pai, who will be with us, of course, for our lunch session today, the agency is already charting a new free market-oriented direction. We'll be spending a lot of time today, of course, talking about the implications of this new course, including what it means for innovation and investment, but most importantly, what it means for our nation's consumers. I have a hunch that at one time or another today, the subject of the FCC's new net neutrality proceeding, or open internet proceeding, as the previous FCC chairman preferred, or restoring internet freedom proceeding, as the current FCC chairman prefers. In any event, that proceeding, by whatever name you want to call it, I'm sure will come up, and it should, because it's an important proceeding for the FCC. Aside from the conversation that I'm going to have with FCC Chairman Pai at lunchtime, we have a stellar lineup for today's program. The first program will feature Howard Shelanski and Boyden Gray here. Again, I've got in your program, you see the titles and bios. Then we're going to follow this session with a all-star panel lineup, and then immediately following the panel session, we're going to break a short time for a very nice buffet lunch. I guarantee you it's going to be nice, but I hope most of you are here for the program and not just for the lunch. And then we're going to have the conversation with Chairman Pai, and then we're honored to have the two acting directors of the Federal Trade Commission with us for the after lunch session. That's Tad Lipsky and Tom Paul will be featured at that session. And then winding up, Michelle Connolly, who is a professor at Duke University and a member of the Free State Foundation's Board of Academic Advisors, will offer some final thoughts. Now, remember to tweet if you're a tweeter. The handle, I think we have the Twitter handle on each table, but it's hashtag FSF CONF9, which should call to mind FSF Conference 9. That's hashtag FSF CONF9. And then before we get started, I just want to take a second to acknowledge and thank some of our staff members that are here. Kathy Baker is our events coordinator and communications coordinator, and so she has an awful lot to do with this event, and we appreciate her. Let's give a round of applause, if we could, for Kathy. And then I want to acknowledge the scholarly work by two of our staff members that are here and their contribution. Senior Fellow Seth Cooper. Seth is going to be moderating the program after lunch, and Research Fellow Mike Horney. Their contribution to our work at the Free State Foundation is very, very important. And then finally, I want to introduce to you our newest senior fellow, Ted Belema. Ted joined us in mid-March. Ted is a PhD economist and a lawyer, and really combines the law and economic expertise. So, Ted, if you could just stand up so people will see who you are. So thanks to all of them. And then finally, I just want to thank, as I often do, but sometimes forget to do, my wife, Laurie. She actually does an awful lot of work for the Free State Foundation that goes unrecognized, a lot of behind-the-scenes work. And when I say that, I'm not even referring to what she does, tolerating without too much grumbling the often insane hours that I put in really for the Free State Foundation. So I appreciate everything that Laurie does, and maybe you could thank her with me. Okay, with that, let's get started with our first session, and I'm just going to introduce our speakers first. With their indulgence and yours too, I'm going to hit some of the highlights of that are in their bios, but again, I refer you to the more complete bios in the brochure. Our initial speaker and really keynoter for the day is Howard Shelanski. Howard is a professor of law at Georgetown University Law School and a partner as well at the Davis Polk law firm. And importantly for our purposes today, of course, he's the former administrator in President Obama's administration of the Office of Information and Regulatory Affairs, which is within the Office of Management and Budget. That position is often referred to as the regulatory czar. I'm not sure whether Howard likes that term or not, likes to be a czar or not, but that's the fact. And Howard, again, just briefly, he's a former director of the FTC's Bureau of Economics, and he also served previously as chief economist of the FCC from 1999 to 2000, and a senior economist for the President's Council of Economic Advisors during President Clinton's administration. So again, and Howard, as well as Ted Belema, has degrees in both. He's got a PhD in economics and also a law degree. By the way, I'm not sure I mentioned it, but the topic of this session, and you will see how Howard and the next speaker I'm going to introduce have the experience and expertise to talk about it, is lessons learned improving regulation and government administration. So it's hard to find someone more qualified than Howard to talk about that, along with Boyden Gray, who's going to be the commenter reactor to Howard's comments after Howard delivers some opening remarks. Now, C. Boyden Gray is the founding partner of Boyden Gray and Associates. He's a former U.S. ambassador to the European Union and a former White House counsel, and also very pertinent to our program today. He was counsel back in the first Bush administration, George H.W. Bush, to the Presidential Task Force on Regulatory Relief, for which he wrote the original Executive Order 12-291. We don't want to get hung up on numbers here, and I have a hard time remembering, but he can fill us in on what that was. Boyden, someone told me once when I had another ambassador on our program, we've had a few, that once you're an ambassador, that title never leaves you, that you're always ambassador. So if I forget, Boyden's a longtime friend of mine, if I forget to refer to you as ambassador, I ask your indulgence with that. The other thing I want to say just about Boyden before we get started is he left off of his resume, it's left off of the official bio, probably the most important position, what I think is the most important position that he held during his illustrious career. He is a former chair of the section of administrative law and regulatory practice of the ABA. Now that might not strike you as being as important as, ambassador to the EU, but I'm a former chair of that section as well of the ABA. And so I considered that to be important. And Boyden, when I was serving my year, it's just a one-year deal, but when I was serving my year as head of the section of administrative law, I was asked whether I could be ambassador to the EU at that time, and because I had that other job, I had to decline that, but I wasn't able to do it. But anyway, now you know about his other position. So with that introduction, I'm going to turn it over to Howard to get us started, and then we'll get Boyden's reactions.
Good morning. Thanks very much, Randy. It's a real honor to be here and to share the podium with you and with Boyden, who's really in some ways just a founder of regulatory review and regulatory reform in the executive branch, and as somebody who, anybody who has worked in my position at OIRA has sort of a pantheon of people who are founders and foundational thinkers in the area, and Boyden is certainly one of them. What I want to talk about today is regulatory process and regulatory reform. And I think there are some lessons learned, at least that I learned, over the last 4 years in the Obama administration doing regulatory review, about what's hard about regulation, what works, and what doesn't work, and why we need to be very careful when we embark upon a series of fixes through legislation, or other kinds of means, because there's some very good things in our regulatory system. There's some things that can use fixing, but fixing them is hard, and we're going to want to proceed very carefully. And I think that that's an important message to get across right now, that there is, I think, a lot of fairly radical rethinking of the federal government's regulatory program. I tend to think radical rethinkings are good things because they stir things up and they get people thinking. But as long as people think with a cool head and are willing to acknowledge that some steps they may take are wrong, back up, try a different path, and also so that we don't rush too quickly into legislation that locks us into what is actually an inferior regulatory system. So I would start with the premise that the United States has probably the best, most transparent, and most accountable system of regulatory process in the world. One of the jobs I had as OIRA administrator was to go around the world, often with our ambassador, our USTR head, Mike Froman, and to negotiate with foreign governments or entities on regulatory reform issues, on regulatory harmonization issues. And one of the things that made that very difficult was that in many places, regulation happens completely out of a black box. There's some kind of summary of a rule or some kind of description of an intent to regulate, some kind of very preliminary report about what the effects of the rule will be, and then boom, a regulation pops out of some back room, and there are very few bases on which one can actually go and challenge that rule and get it rethought. Compare that to what we have under the Administrative Procedure Act. There are a few exceptions, but by and large, an agency has to issue a proposed rule. That proposed rule has to go out for public notice and comment. The agency then has to issue a final rule that is built upon the record that includes that notice and comment and the response that the agency makes to those comments. And at the end of it all, the agency is subject to judicial review. This works fairly well. Lots of rules get challenged in court. Lots of rules get remanded or struck down in court. Sure, that's a costly process. But if you think of the incentives that it generates down through the stream for agencies to do a good job in rulemaking, one can see that it's not a bad system. The public is involved early on, and the public has a chance to call the agency to account at the end. That is rare. Not only that, what the public gets to comment on is the rule. What the public gets to see in support of that rule, especially if it's an economically significant rule, is the regulatory impact analysis. Not a white paper describing the rule, not a white paper describing what some people think the effects might be, but the analysis, things that can get challenged, things that can be brought before a court. So one wants to think twice before one backs up and fundamentally changes a system that actually has, even if not perfect, even if not costless, a pretty good system of transparency and accountability built into it. It's a very rare kind of thing. Now let me back up and talk about the things that I think are lessons learned and lessons learned about things we need to fix in regulation and what we might do to come up with an even better regulatory system going forward. So what is the job of a regulator or a regulatory review office? I throw that in only because that was my job. So the first is to identify a real problem. This may sound like an obvious statement, but it is not always the case that regulations that agencies issue address problems that are genuine, that is to say, occurring or very likely to occur. Sometimes one sees regulation that is well meant to get ahead of a problem, to stop it before it starts, but without sufficient grounding to be sure that the problem is actually going to occur. That is a very weak foundation on which to do regulation, because then the benefits, which as I'll talk about in a minute, are always a difficult thing to make salient and to prove, become even harder because not only are the benefits hard to examine because they're in the future, they're highly contingent on the problem even occurring. And it's very hard to make a good case for regulation and very hard to make a case to the parties that must bear the costs of that regulation when the regulation to begin with is the benefits of the regulation are contingent on a problem actually occurring. So identifying a real problem and having a convincing case that this is a problem that society should solve and bear the costs of solving is the first issue. And I'll just start by saying I think sometimes there is insufficient attention to making that case. Agencies could do a better job making that case. It's not not typically what agencies are set up to do. They look at their statutory authorization. They look to a mandate from Congress or a petition from the public or some event that has happened out there, and they respond. The communications aspect of explaining what they're doing and why they're doing it is not always done very well. Sometimes that's because that's a hard case to make. Well, that's all the more reason that agencies should have to get out there and make the case. If it's a hard case to make, that suggests there might not be a real problem, or that the problem is one that is too costly to solve. So identifying a real problem and communicating and making that case convincingly is, I think, the first step in rulemaking. The next step is to identify potential effective solutions to that problem. And I say solutions because, again, another shortcoming that I find even within our overall quite good regulatory system is agencies tend to move very quickly towards a solution to a problem. Now, that is not always the case by any stretch of the imagination. But one of the things that I found as administrator of OIRA was that many proposed rules on very significant issues came into the office without much examination of regulatory alternatives beyond the proposal that the agency was making. But regulatory alternatives are important. Discussing them, even analyzing them in a quite rigorous way, because they show the public, when the rule goes out for notice and comment, what else might be a possible approach? What are the other things that the agencies thought about and rejected, or at least became less convinced were appropriate solutions to the problem? There are a number of reasons one wants to do that. Different alternatives will have different cost-benefit profiles. Different alternatives will elicit different kind of data and comments from the public. And actually, the agency may find out something that they, inside their closed circle of people working on the rule, they may find that there's information that convinces them they made a mistake, that they should pursue one of those alternatives, that they should go back to the drawing board. So identifying potential effective solutions to that problem, and even if the agency proposes one of those, to nonetheless be transparent in discussing and explaining what alternatives there might be. This, by the way, is in the executive orders that govern regulatory review in the executive branch. They've been there. I can throw out a lot of numbers. In Executive Order 12866, Executive Order 13610, all of these great executive orders that actually, since President Reagan, every administration, regardless of political party, has seen fit to reiterate and strengthen on very similar principles of regulatory review. So alternatives are a big one. Now, the third thing that I'm about to identify here is probably, in some sense, the most controversial. And that is to determine that the proposed solution, and indeed any alternatives that might be discussed and offered up as possible proposals or possible rules down the road, proposed solutions to that problem should not impose costs that that outweigh the benefits of solving the problem. Now, that sounds obvious. Why would we undertake a rule that is more costly than the benefits it brings? But this is, of course, an extremely fraught exercise. Now, the executive orders do not say, and I think they're right not to say, that the quantified benefits of a rule must exceed the quantified costs of the rule. And I think one of the biggest mistakes that can be made in regulatory reform would be to issue a mandate that says, no rule shall be issued whose quantified benefits do not offset its quantified costs. That would be a disaster for a number of reasons. First of all, there are rules that this society chooses to put in place that have non-quantifiable benefits, distributional objectives, fairness objectives, objectives of social inclusiveness. One may agree or disagree politically with those objectives, but if they are disclosed, if they are well achieved by the rule, and if the rule says part of the reason we're going to achieve these costs is so that same-sex families in the military can have access to base housing and feel more included and be better soldiers, well, how do you put a dollar value on that? Pretty darn hard to do so. It's a dignitary interest. There's not a quantifiable benefit unless you really stretch and do a sort of not very credible kind of quantification. There's an immediately and easily quantifiable cost how much more base housing you're going to need. You would not be able to have that rule if you had a rigid quantified benefits outweigh quantified costs rule. So the executive orders talk about benefits that justify the costs of a rule. That's squishy, I'll admit it, but I think it's important to be a bit squishy because I think it allows society to make decisions that it's going to have regulation that doesn't have benefits that are easily quantifiable or that are purely distributional and actually cost society something because we as a society want to pay for those things. That said, I do think it is important that the public know very clearly what it is paying to get those kinds of benefits. So the disclosure of costs, all costs, that can be quantified or that can be identified even if not well quantified, that are going to be incurred in the pursuit of those benefits, as a matter of democratic process, have to be put out there very clearly and transparently. Now, agencies hate to disclose costs and they love to tout benefits. One of the jobs of a regulatory review office is to right that balance. Now, I think we're actually going to see some very interesting things happen under some of President Trump's executive orders. If one has to repeal 2 rules to issue a new rule, something that is at least aspirationally sought in one of the president's executive orders and will be quite hard to do, we're going to see the agencies flipping on costs and benefits as they come forward urging repeal of certain rules. To repeal a rule, you have to make a rule. You have to make a rule repealing the old rule. Under the Administrative Procedure Act, you can't just say, never mind, we're not doing that anymore. Once that rule is out there and published, it is a change in regulatory policy to repeal it. You've got to do that on a full APA process, fully disclosed on the record, subject to judicial review. That means you've got to explain why your previous record was wrong and why facts and evidence today suggest repealing the rules. The things that were the benefits of the rule that was originally passed are now going to be the costs of repeal. And one saw this highlighted very well in an interesting exchange on Fox News between Chris Wallace and EPA Administrator Scott Pruitt. Administrator Pruitt talked about repealing a bunch of greenhouse gas emission rules. Chris Wallace said, what are you going to do about the 90,000 cases of asthma that those rules are preventing? Now, that was a very interesting question to ask because if you're going to repeal the rules, there's a cost to society. So my bet is agencies are now going to come around and say, those rules were not so beneficial, but boy, they were really costly. The opposite of what agencies really do. One again needs a truth teller, an office that's going to rigorously review those analyses and quantifications. So even within our very good system, there are incentives for agencies to bias costs and benefits in the direction that's going to achieve the policy they want to achieve. So an independent review office is important. I think that the office we have in place does a pretty good job. I think the ability of courts to review the record is yet another backstop. How much farther one would want to go in imposing cost-benefit requirements or mandatory layers of judicially reviewable review of those rules is, I think, a hard question. And I worry a little bit about some regulatory reform efforts that say, well, make OIRA reviews mandatory to the agencies in every case with cost-benefit analysis and make those reviews judicially reviewable. Well, if one were to do that, you're going to get collusion between OIRA and the agencies from the beginning, not to make better rules, but to make the rules as judgment-proof as possible. One wants a separation between the Regulatory Review Office and the agencies, not collusion. One wants the Regulatory Review Office that's going to argue back and forth and call out the agency for the problems and the mistakes it makes. Anything that would make any of those communications evidence that the rule should be overturned will eliminate those communications and I fear, put the review office into more of a collusive posture. So again, another area where I think one wants to be very careful about reforming regulatory review. I just want to come back and talk a little bit about costs and benefits and then return to a couple of examples that I think highlight some of the challenges we face in regulation. The political dynamics of regulation are always fraught. They're always difficult just because inherently the political economy of regulation is unbalanced. Costs tend to fall on a fairly narrowly defined set of parties. They tend to be relatively short-term in their occurrence, relatively relatively measurable. And so anytime there's a rule, the people who are going to have to pay for that rule, they know they're going to have to pay for it. They have a good idea of what they're going to have to pay. And they're often not the parties who are going to directly receive the benefits. Now, that's not actually a problem. If they're the party that's causing the costs, they should pay for them whether they're getting the benefits or not. You impose a burden on society, you should pay to fix it. Pretty basic economics. But that's actually not the most common situation in the world. Often the parties that have to fix a problem are fixing a problem that is more social in nature, or that is one where they are simply the least cost avoider, even if they are not the cost causer. And it is a harder case, and one needs to think a little bit more broadly about justifying those costs. But the point is, there's always a strong and vocal and organized constituency to oppose the costs. Now think about benefits. Benefits can be more speculative, more probabilistic, farther in the future, and much more diffuse. If you're a coal mine and you're told to reduce the amount of respirable coal dust in the atmosphere of the mine, in the air of the mine, you know immediately what it's going to cost you to do that. If you're a coal miner, that might all sound good, but you don't know if you're ever going to get black lung disease. If you're going to get it, it's 30 years down the road. There's no salient immediate benefit, except that your employer is telling you, my operating costs are going up, I'm going to have to trim some benefits or trim some jobs. The benefit side of that is a lot less salient. If we were to leave regulation to open politics, rules wouldn't happen. Some rules would, but in response to emergencies or true crises. The result is we have a political dynamic of very strong public advocacy groups on one side saying failure to regulate is a disaster, and advocates for the parties that are going to bear the cost saying, no, regulation is a disaster because it's going to kill jobs and ruin investment. The truth is always somewhere in between. Regulation is not a game of extremes. It's not a binary do-don't. It's a game of trade-offs. It's an enterprise of analyzing how we solve problems in ways that best balance the costs and benefits. The parties that bear the costs need to acknowledge that there are benefits and work to find a better way to achieve them. The parties that are going to get the benefits and advocate for them need to understand that there are costs, and you cannot ignore the consequences of imposing those costs, and work for more efficient and more incremental ways of achieving regulation. Right now, that's not the political dynamic, but that is the dynamic within the agencies. And I think agencies need to be left to doing that careful balancing and that incrementalism in the transparent and accountable system that is the Administrative Procedure Act. One concern I have about one of the biggest proposals for regulatory reform is out there is that it will interfere with this process fundamentally. Agencies need to be able to build a record, not have that record challenged midstream, but wait till it is completely built. Wait till a final rule is issued on a complete record, and then that rule can be challenged in court. There are proposals out there to have interim records that are part of a proposed rule challengeable in court. That prevents the agency from perfecting the record, and I use perfection in quotes, but to doing a better job with the record based on the feedback that it gets back from the public comment process. It actually allows challenges at an earlier stage. The way that agencies can avoid these unbalanced political dynamics and actually solve real problems is to have the opportunity to build a full record, and that way it will come to a court to decide, is there really evidence of benefits? Is there really evidence that these benefits justify the costs? Has the agency done a good job on both the costs and benefits side? And make a determination based on that evidentiary record, based on the analysis. If we start leaving it to the political realm, we run into, I think, significant problems and much lower quality rulemaking. Now, I want to return to what I think is at the foundation of sound regulation. the identification of real problems, and the identification of really workable solutions. I do think that agencies get off on the wrong foot, and the whole process that I think makes the APA work well falters when there are rules that are generated because of a belief or a big movement that claims that there is a problem to be solved without real evidence that the problem truly exists. In 2007, I wrote an article. It was called something like Network Neutrality, Regulating with More Questions Than Answers. And I went through sort of both sides of the, or multiple sides of the network neutrality debate. I said, well, you know, each side could be right depending on the answers to some very hard questions. Questions about investment incentives, questions about the marginal value of different investments, questions about the true economic incentives that different parties would have to discriminate or not discriminate. And I tried to make the case that those questions were not well answered. And I wrote the article because I was perplexed by the incredibly adamant arguments that we had to have regulation now, today, yesterday, to stop all of this horrible stuff that wasn't yet happening. I think that it's important as the FCC goes forward in re-examining rules that were issued in the last administration to look carefully at what questions we have the answers to, what questions we don't have the answers to, and not to be afraid to deregulate where mistakes were made, but also not to be afraid to stick with regulation where the evidence shows it would not hurt investment and, in fact, would achieve some good. I think that's why I sort of started out by saying I think a radical shift in direction can be a healthy thing from time to time. It can change perspective, get people to think very differently and to re-examine things that had been long assumed. But I think one cannot head blindly in one direction, regulate, deregulate. It's got to be a period fundamentally of reanalysis and re-examination. It is my hope that that's what will happen as the commission goes forward. One final note. Often the actions of agencies are pilloried in the public. This is tough, but I would urge agencies to stay the course. I thought it was very interesting that most newspapers, not all, but most, came out adamantly against the repeal by Congress of the privacy regulations that the FCC put in place. Insufficiently covered, in my view, was the fact that this was really a question of comparative institutional competence and a restoration of the privacy function to the agency with much broader jurisdiction over that and much more experience, the Federal Trade Commission. It wasn't leaving the space unregulated. It was changing the structure and approach to regulation. That message didn't get out there very well. I commend Chairman Pai and Acting Chair Olhausen for their excellent editorial on the issue. But whether or not that ends up capturing the day, it happens to be right, so they should stay the course. And I would urge all agencies as they go forward in regulating or deregulating to adopt a similar posture. Do what is right. Do what careful examination of a rigorous record would show to be correct. And don't worry about the noise on the outside. Thank you.
Thank you very much, Howard. That was a very stimulating, important address to lead off the conference. And now we'll hear from Ambassador Gray. And then after Ambassador Gray's remarks, hopefully we'll have time for a few questions from the audience. I always like to do that when we have time. Ambassador Gray.
Well, thank you very much. As just a preliminary matter, I want to make it absolutely clear that Howard has done a really good job of maintaining the credibility of OIRA, which is absolutely essential to keep a close monitoring on the value and the utility and the importance and the need, especially the need for regulatory activity. And I'm there were certainly obviously temptations, pressures to relax. In the last administration, Howard never did it. OIRA is still as strong as it used to be. It needs a bigger budget, but it's in good hands and in good shape. So my thanks to you, Howard, for doing, not thanks, but commendation for maintaining a very strong tradition. I also want to say at the outset that I'm really sad, Randy, that you didn't take that job. I'll tell you one of the best benefits of it was that I lived in a residence that had been built or renovated by a Russian oligarch who was so disfavored in Russia that he thought he would live out his years if he could in Belgium rather than in Russia, where he was being pursued by all manner of people that he had bilked. And so he did this marvelous residence. But he was so bad, it turned out, that the Belgians would never give him a visa. So the State Department picked up the residence, and that's where I lived. And when I was introduced to it, I had these local Flemish intelligence authors, experts tell me that this was the safest residence in the entire European Union system. Not an unimportant thing, since we know of the radical cell that lived in Belgium that was responsible for the attacks in Paris.
Well, I should make clear, just so an urban myth doesn't get started, that was only a joke. But now that I know about the Russian connection, if it were true and if I had been offered that job, then I'm glad to know what Boyden just related.
Well, you don't know the full of it yet. The intelligence experts said that I had the highest end safety equipment, triple mylar windows, electronics that no one can make work. But the centerpiece of my safety were huge, thick 6-inch doors protecting my bedroom. Just think of what you missed. And these were known as 4th century doors. And I didn't have enough courage to ask for at least one briefing, what on earth is a 4th century door? And why? Why 4th century? Why not 3rd, 5th, or maybe even 21st? And a 4th century door, you might wonder what it is. A 4th century door is that door which, in order for you to have a half an hour to call the police in case you're under attack, could withstand anything that could be thrown at it in the 4th century. A very useful thing. I used to tell this story because I had to give lots of speeches after dinner when people had too much to drink and didn't really want to get into the intricacies of net neutrality or whatever it was, and people would laugh. And then my communication specialist came up to me one day and said, you must stop talking about the 4th century door because it's going to heap disgrace upon yourself, your mission, and your country. And I said, why? He says, no such thing. But I've been twice briefed, but they're wrong. What do I have? He said, what you have is not a 4th century door, but a forced entry door. So you can see how it's so easy to get mixed up. And languages, and sometimes, well, I don't argue about the quantifiable, non-quantifiable costs. It is very important to get as good a handle as you possibly can on what is actually going on with a rule that is about to be implemented. And facts are very important. And to understand, is there a real problem, is very important. And I commend, again, our speaker for looking at that. I don't have much time, so I'm just going to go off into a little bit of a tangent. The identification of a problem is where he started, and it really is the key. And often agencies will just take flight, and they will take, under the infamous or famous Chevron doctrine, any hint of an ambiguity in a statute has authority just to go flying off into the sunset. And sometimes the problems that they seek to cure just plain don't exist at all. One of Scalia's best lines at the end of his life in one of his last decisions in the famous URAG case, that's the case involving EPA and climate change and tailoring, and I'm saying this knowing that the President has apparently just pulled out of the Paris Accords. The harms that EPA was arguing just plain didn't exist, and the statute talked in terms of big installations creating big pollution emissions, and this is not a CO2 kind of thing. CO2 can come out of a house, can come out of an office building. You can't cover everything, and the statute talked of 200-ton emissions limit, and EPA said, well, that doesn't make any sense. We're actually, the statute, the statute actually meant was 100,000 tons. So that's where we're going to start, and we're going to tailor, it's known as a tailoring, we're going to tailor the statute to fit what we think is the problem. And at one point, one of the cases said maybe you have to make that jump from 200 tons to 100,000 tons. You may have taken the wrong route in figuring out whether or not there's a real problem. And there wasn't really a problem, and in my opinion, and Scalia writes his opinion saying we're not going to sit idly by on the dock and wave goodbye to EPA as it embarks on its voyage of discovery. We're not going to sit idly by on the dock and wave goodbye to EPA as it embarks on its voyage of discovery. Now, in the net neutrality rule, which was affirmed by a panel of the Court of Appeals, as you all know, and then went to rehearing, which was en banc, which was denied, two dissents emerged, and they were powerful enough from Judge Brown and Judge Kavanaugh. They were powerful enough that it prompted a retaliatory opinion by Srinivasan and Tatel. And if you all want to know the current state of thinking about how to look at these issues with a broad brush, assuming that the hard work of figuring out, all right, what are the costs and benefits and whatnot have been done. Assuming all that's been done, if you want to look at the big picture, I would commend that you all read these three opinions. The lead opinion by Srinivasan, trying to rebut, or rebutting, it depends on your point of view, of course, the two dissents. And Janice Rogers Brown steals a little line from Scalia, mimicking his, we're not going to sit idly by. She doesn't talk about the dock, but she does say we're just not going to wave goodbye to the FCC and let it wander around in the sunset, just going wherever it feels like going. And this is part of the problem. Agencies can take off in full flight under the way Chevron works, and that's where some of the most reform-oriented efforts are being pointed. And it's the courts that I think are going to have to do this first. I don't know how the Congress fixes something that was a court problem to begin with, but I think the courts are watching this very, very carefully, and I think you'll see some of the best writing on this in some of the opinions of the new justice about the relationship between non-delegation and the Chevron doctrine. And I think that what's going to happen is the courts, this is maybe hope more than prediction, but the courts are going to begin to pin the agencies, or really more precisely the Congress, back and say, oh, you can't do this, it's too broad, there's no call for any particular action, you have not identified a real problem, you've just thrown up your hands and said, go regulate, and that's not enough. We have nothing to review on, and Chevron doesn't apply when you have a non-delegation problem. Chevron doesn't apply when you have a really big issue like net neutrality. And so we're going to decide what the law is, and we're going to decide that maybe your law is just too vague, broad, and open-ended, and you better go back and do it right and start again. Now, I don't know that we'll see any cases thrown out like Schechter was in 1937, but I think we'll see a lot of case law in the future narrowing these statutes to the point where it's going to give Congress a little kick in the you-know-what and make them be a little bit more precise. I'll end with a question, because I did a lot of legislative work when I first came to Washington and saw these markup sessions where food fights would take place at call in the parliamentarian, and they were really good drama. They were really good entertainment. And I have asked audiences, how many people have ever heard of an amendment to the third degree? Are any hands going up? I see one. Maybe one there in the back. That's sort of discouraging in a way. How many people have actually been to a markup session? Well, more hands, but not very many. You'd think most of the hands would go up. And that's the problem. We need more markup sessions and more amendments to the third degree. So thank you very much for the opportunity to speak.
Well, if you're like me, you're probably thinking, gee, maybe we could just have the rest of the day, with a session with these two. Unfortunately, we're not going to be able to do that, but we've got a little more time. I will say when I gave that introduction of Ambassador Gray, I didn't mention that he has his degree from the University of North Carolina. I think he was editor-in-chief of the Law Review there, and as many of you who know me well and have heard me say at previous conferences, I'm a double Dookie. I have 2 degrees from Duke University, so only someone that's exceptional, like Ambassador Gray, that went to the University of North Carolina would ever actually appear on one of my programs. So that's to your credit. Well, that was terrific. I want to ask a question, actually. No one touched on this, but among the audience here, it's a topic that everyone's familiar with, and I think your reactions would be useful. Chairman Pai instituted a new practice at the FCC a few months ago. I think he's now decided it's going to be permanent. And the practice is that he releases draft ordered NPRMs or orders at the same time he circulates them to his fellow commissioners. That's 3 weeks before the FCC Sunshine meeting. The issue came to a head and first came up basically during the last round of the net neutrality proceeding when many Congress people and others were asking to see the draft order. And it was considered at the time, and still may be by many, to be fairly controversial because it hadn't been done. But now it's been done. I'm going to ask him about it during our lunch conversation and probe a bit. But you two have had so much experience with the agencies. What's your reaction to this new way of doing business at the FCC in terms of making public these draft rulemaking proposals? Someone go first, if you wish. Or
I think we have to see how it pans out. There are possible pros and there are possible cons. To the extent that a chair of a commission is releasing a draft order that comes out of the chairman's office that other commissioners have not had a chance to weigh in on, or that perhaps only a subset of commissioners have had a chance to weigh in on, there is a potentially problematic aspect in that it brings the public in at an early preliminary stage before the commission has done its internal deliberative process. And while I think on one hand it can be viewed as transparency. On the other hand, it can really interfere, I think, with dialogue among the commissioners and their releasing of a regulation that actually speaks for all of the commission in a more balanced way. So there is the possibility that that it could lead to it can be a strategic play to limit the input of other commissioners on a controversial issue. Certainly at OIRA, I fought tooth and nail against opening up all of the discussions that OIRA was having with the agencies and all of the interim drafts for exactly the same reason. We needed the ability to tell the agency, you're wrong, fix this, ask hard questions, and then put a draft out to the public that had gone through all of that internal deliberation. So, I can see some positive things from it, but I think we'll have to wait and see how it actually works out.
Boyden, do you have any reaction at all?
Well, this may not be exactly on point, but the internal deliberative process is very, very important. Having been involved in it many times, I am quite partial to it. As an outsider, sometimes I wonder if it doesn't shield agencies from the kind of transparency that Howard's talking about. And so there is a balancing act that goes on here, and it's a tricky one, and it's going to continue to be a tricky one, I think, probably for a long time.
Okay, I'm going to ask one more question, and then we may have time for one or two from the audience. But Howard, maybe this is to you. As you may know, the FCC, when it released its notice of proposed rulemaking for this round of the net neutrality saga, it specifically is asking for a cost-benefit analysis. Most of you know the independent agencies are not required by the executive orders, if I still understand this, to do these, but it's something that the FCC is doing, and many people have recommended that the agency do for the reasons that you talked about. I just want to know, how common is that among other independent agencies to undertake what I think will be a fairly formal cost-benefit analysis by the FCC in your experience?
Thanks. It's been a mixed bag, and even sometimes the same agency will sometimes do it and sometimes not. For example, in the case of the CFPB. My own view is that all agencies should have to do this. I do not believe, and I think I'm the only OIRA administrator ever to say this, at least Senator Portman tells me I'm the only one to take this position. I don't think that the independent agencies should necessarily be under OIRA review. I do think they should have the obligations, however, to undertake the kind of cost-benefit analysis that the executive order requires, because otherwise I think the public really doesn't have the full kinds of information and record it needs to comment in an informed way on the rules.
Okay, thank you. For all those standing back there, there are scattered seats. It's fantastic to see this huge crowd. That's gratifying. But there are seats up front. Even if they have a sign that says reserved on the seats, you can occupy them now, and that'll be fine for now. What I want to do maybe is take one or two questions from the audience. I want you to raise your hand if you have a question, and I'm going to recognize you and wait for the mic to be brought to you, and let's keep the questions succinct, please. Looks like Alden Abbott.
Thanks very much, Randy. Alden Abbott, Heritage. Question for Howard. There's been a number of studies show there's been a great growth in guidance documents and informal sorts of quasi-rulemaking, which really don't fall under terms of executive order. And some have raised concerns that these raise a real problem, totally apart from concerns about due process and so on, but cost-benefit analysis. These are things that are not seen by OIRA. Should that change? What's your view about that?
Thanks, Alden. It's a great question. And in fact, Senator Lankford has held hearings on this in which I've participated. I think as a general matter, it would not be practical for an office like OIRA to review all guidance documents. Guidance documents, when they are done right, are interpretive, they are non-binding, they do not create new regulatory obligations. And I think to review every single one of them in advance to determine whether they violate those boundaries would just be an enormous amount of work and probably not an efficient use of resources. On the other hand, agencies do on occasion overstep and try to effectively regulate through guidance document. The good news is that most of the time they're called out on that. They're challenged and they're told that they can't do that. I think what there has to be is some kind of rule that basically says that a guidance document cannot have effect if it does not, if it has not gone through a certain process internally at the agency and been posted in a way that is transparent with an explanation of how it relates to the underlying rule. What that would mean is an agency could not come out and say, oh, our guidance document over here means that you can't store those chemicals in this way anymore, just to take one particularly controversial example. We used to say you could, but now you can't. Wait a minute, that's a change in regulatory policy. Don't you have to do that by rule? So by having a public posting requirement and an explanation requirement, and maybe even a public consultation requirement for significant guidances, a lot of the problems can be resolved. There's a terrific Bush II administration document, a 2007 document published in the Federal Register, which is an OMB guidance on guidance. We actually recirculated it to agencies, said this really matters, and I think that that's something that could perhaps be embedded in statute to make the requirements even stronger.
Boyden, do you, on the issue of guidance documents, have anything you want to add? Or I think this will be the last comment, so if there's anything you want to add at all, briefly, please go ahead.
Well, I agree. I don't think it's a routine matter. You can possibly look at every guidance document, but I think for the ones that really have impact, you'll hear about them and you'll know about them, so I'm not really worried about it. My ending comment would be to change the subject back to the CFPB, the Consumer Finance Protection Bureau, and the fact that it is shielded. You're not even supposed to look at anything they do, I think, so I'm surprised you even mentioned them. But anyway, they're free of all constraints and all accountability and all transparency, and they spent, because to take their funding comes from the Fed. The Fed's required to fund a certain amount and then prohibited from intervening at all in what the CFPB does. Congress has no power of the purse, but he does have to testify cordially occasionally, and he did testify, and it turned out they had spent several $100 million on the renovation of their headquarters, and one of the subcommittee chairman of the House Financial Services Committee said to him, well, who was in charge of this rather lavish renovation? And his response to this member of Congress was, what does it matter to you?
Okay, well, I think what matters to me right at this moment is that I think you'll agree that it would have been difficult to find two other people with more experience and background, scholarly experience, but more importantly, practical experience in the area of regulation and to talk about lessons learned. So please join me in thanking them both.
Thank you.